Masechet Baba Kama Daf Mem Gimel. We're continuing a discussion of Rabbi Akiva's explanation of this pasuk. V'mit ish o isha, if an ox gores a man or a woman, then you stone the animal and the kofed is paid. So for a shor mo'ad. Question is, why do you have to say ish or isha? We already know from the previous pasuk where it says man or a woman. So surely the punishment would be the same for a man or a woman. Why do you have to say this? And Rabbi Akiva explains that was talking about who will inherit. If an ox gores a man, and he dies, so who gets the payment? His heirs. So too, if an ox gores a woman, a married woman, so she is dead. So obviously she's not getting the money herself directly. Who gets the money? You might have thought the husband gets it because the husband inherits the wife. But no, the word isha comes to teach us that her heirs inherit the kofed, which means he pays it. The owner of the ox pays it to her heirs. Good. Now, Rabbi Akiva, he did say in general that a husband inherits a wife. So the question is, how come here, why is this different? I know you have a pasuk, but why should it be different? And so we explain that there is a difference between money, that property that is already in the estate, already is owned by her, versus receivables, that's ra'ui, versus muhzak. Muhzak, anything that's already in the estate, when she dies, that goes to the husband. But something that is ra'ui, that is only owed to the estate but not yet there, does not. And here, since the payment cannot possibly happen until after she actually dies, even though let's say she's sick for a little while, but it's not until she actually dies. Only then does the shor get the sekila, and only then does the owner of the ox have to pay. So since the payment is only coming in by definition after the victim dies, so therefore there is no payment at the time that she's alive. That's not in the estate, so the husband doesn't have any right to it. That's all that we said yesterday. So therefore we see kofed is an exception to the rule. It's true, Rabbi Akiva thinks that the husband inherits his wife, but not for kofed. Okay, and we have a pasuk that proves that is the case. Now we ask, Ubenizakin, lo amar Rabbi Akiva? Hold on, Rabbi Akiva. Is that true? Kofed is the only exception to the rule that the husband inherits his wife? What about nizakin, a payment for damages? Not kofed if she dies, but damages, as follows. V'hatanya, hika et ha'isha v'yas'u yeladeha. If someone strikes a woman who is pregnant and causes her a miscarriage, now he has to pay all the things. Noten nezek v'sa'ar la'isha utme v'ladot la'ba'al. He pays for damage and pain to the woman. Well, she's the one that felt the pain after all. Okay, so that does make sense. But the compensation for the miscarried fetuses, that goes to the husband. Idea is he's the head of the household, he's the father of the house, and so the compensation for the fetus goes to him. Now, en ba'al noten li'orshav, en ha'isha notenet li'orsheha. If the husband, there is no husband because he died, then it goes to his heirs, the payment for the fetuses. And if there is no wife because she died, then the payment for nezek and sa'ar go to her heirs. This is the key thing that we're looking for. You see here, this is a payment of damages, meaning she's still alive when the damages are owed, all right? Because she didn't die from that. Someone hit her, she lost her pregnancy. Now that guy owes her money, right? He didn't pay yet, and then she died. So at that point, according to Rabbi Akiva's logic, wouldn't it make more sense that since this is owed to her, so then when she dies, the payment should go to the husband? All right, why does it stay with her? Right, and so right, Nizakin, Rabbi Akiva, would he not also say that that's another exception? Because look over here, it says that the wife gets it. Now, we've just finished the Braita with a not related case. if a man hit a pregnant woman who is a Shivcha Kana'anit, who became free, so now she's Jewish, or she's a convert, the common denominator between both of them is that they have no heirs. Their biological relatives are not their legal relatives. So she has no relatives. And even let's say she was married, but her husband died, and her husband was himself a convert, who also doesn't have any heirs, and they didn't have children, and so on. So if there are no heirs, then the assailant benefits because there's nobody to pay it. So there's nobody to claim the money from him. So he gets off scot-free if he does that. All right, that's the end of the braita. And so now the question is, in this braita, why doesn't the husband inherit the wife? Right? After all, the occurrence happened while she is alive, and therefore at the time that she died, this is a payment that's due to her, which the husband should also get, like the same way he would inherit a loan that's due to his wife that is there and current. Amar Rabba bigrusha v'chen Amar Rab Nachman bigrusha. Rabba says, this baraita is only talking about a case where she had been divorced. Let's say they were married, she became pregnant. Then they got divorced while she was pregnant. After they got divorced, so at the time of divorce, right? He owns probably all. He owns what he owns. Anything she brought into the marriage or made herself, she keeps. Right? They divide the assets according to halacha, according to what it says in the ketubah. Good. After that, she's still pregnant. A man comes and causes her to lose her pregnancy. At that point, she receives the money herself because the husband doesn't get it anymore, and therefore the money is due to her. If she dies after, obviously her heirs will get it because a husband doesn't inherit his ex-wife. Right? This is his ex-wife. When she dies, anything that she then has goes to her heirs. That's what we're talking about. Rabbah and Rav Nachman say, but you're right, if she had been married, then yes, you're right, it would go to the husband. Now we ask about that. If she's divorced, would the husband really get all the money for the payment of the fetus? If she's divorced, then shouldn't she get half of the compensation for the fetus? Like, I understand when they're married, that he's the head of the household, and although she's bearing the children, she has some partnership in the development of these fetuses, even more in a way. But still, okay, the father's the head of the household, and so he should get that money, and he'll use it for building the family in the future, and so on. Okay, good. I understand if they're married, that the payment of the fetus goes to him, he's responsible for the kids. But if they're divorced, then it doesn't make sense. She should get some of it. That Baraita said that he gets all of the money for the vladot. So Amara Papa Torah ziketa deme vladot ba'al afidu ba'aleha biznut ma'itama Amar kera kasher yashit alav ba'al ha'isha. The Papa said, yeah, you're right. It would make sense. It's logical that if someone's divorced, then she should have a share in the payment for the miscarried fetuses. But the Torah said so, that the husband gets all of the money, even if they were never married. A man and a woman have extramarital intercourse, and she gets pregnant. And then someone hits her, and she loses the fetuses. Even in that case, the man gets all of the money. Why? Because the pasuk says, "Kasher yashit alav ba'al ha'isha," as the literally husband of the woman will assess. But we're reading Baal not as husband, but Baal as a verb. Whoever is the one who had relations with this woman, he gets the money for the fetuses. So there you go. It's a Gezarat HaKatuf, and that explains why. Okay, good. So now we understand this is a case of divorce, and that's why everyone would agree, even Rabbi Akiva would agree that she gets the money, her heirs get the money. But if they were married, then indeed a husband inherits his wife, even for the payment of Sa'ad and Nizikin. If she dies, then the husband would get that payment. Okay, now we ask, ונוקמה לרבה כגון שגבו מעות, ולרב נחמן כגון שגבו קרקע. דאמר רבה, גבו קרקע יש לו, גבו מעות אין לו. רב נחמן אמר, גבו מעות יש לו, גבו קרקע אין לו. Hold on, why do you have to say that Braita is talking about a case where they had gotten divorced? That was the answer of Rabbah and Rab Nachman. But each of them actually has a better answer that they could give. According to Rabbah, why not say it's where the Bet Din had already collected cash from the assailant and they're holding on to it, and that's when she died. Or according to Rav Nachman, it's when they collected land to pay for the nezek and sa'ar, and they're holding on to that, and then she died. Why? What's the difference between these two? Well, in general, Rabbah says, the Rabbi and Rav Nachman here are talking about also in case of inheritance, but here this time for a firstborn. The law is that a firstborn gets double, but he gets double only of that which is muhzak, that which is currently in the possession of the father when he died. Then the firstborn gets double of that. But if it's ra'ui, if it's only incoming receivables, right, just an increase that comes in later, the firstborn does not deserve double from that. So what's considered ra'ui and muhzak? Rabbah and Rav Nachman have a machloket about that, and they say the opposite of each other. Rabbah says if they collected land and the land came into the possession of the inheritance after the father died for a loan, let's say, then the firstborn gets a double of the land. Why? Because even when the father was alive, he had a lien on the land to pay for the loan. So the lien is kind of like possession. And so even though, they had to go to and actually get it, physically take it, nevertheless, it's as if it's already in, and therefore the firstborn gets double of the land. But if they end up getting paid from cash, then not so. Cash, there's no lien on cash, and therefore the cash is considered ra'ui, something that only came in after. Rav Nachman thinks the opposite, that if they collected money to pay for the loan, well, the loan was money that the father had lent out, and now there's some money out there, so we consider that as if it's already the property of the father. It's just that it has to be paid up, but that money is considered already the father's, and therefore the firstborn gets double from that. However, if they collect it from land, he thinks the opposite, that a lien is not ownership of land, and therefore a land, you got to go through a process to go and actually get the land. It's more complicated, and therefore the land is considered ra'ui and doesn't go to him. So therefore, since we know that, according to Rabbah, who says that money is not considered part of the inheritance, if it comes in later, it's not considered part of the father's property when it comes in later. So Rabbah can explain this baraita as being that when she died, and she lost her fetuses, and the Bet Din is collecting from money, but she died in the meantime, and so this money that they collected is not considered part of her property when she died. It's only ra'ui, because it's only cash, and that's why in that case, since it's ma'ot, it could be that they're actually married. You don't have to say divorce. They're married, but this is only receivables. It's only ra'ui because it's cash, and that's why her heirs get it. Rav Nachman, on the other hand, could say it's talking about a case where the assailant paid with land. And the land, as it was being collected, but she died before it was fully collected, and so he says that karka is not considered. We don't consider the lien to be ownership, and so that was not within her property. It was not muhzak. It's only called ra'ui because it was only land, and that's why, since she died and the payment was only coming in through karka, that's not considered muhzak. It's only ra'ui, and that's why her heirs get it. So you see, you could have a better solution. This is better because you don't have to say that the baraita is limited to a case where they had gotten divorced in between. This would be most cases they're married, and it is equally possible that the assailant would pay with money or with land. So you could make this ukimta is easier to make than that saying that they're divorced. So why don't they answer that rather than say that the husband and wife are divorced? And the answer is Hanemi lelibnei ma'araba alibad Rabbanan. You're right. When the Rabbah and Rav Nachman said these explanations, they were only saying that according to Rabbanan for the West. In the West, they follow the opinion of Rabbanan, who say that the rights of the firstborn are limited to the father's property, what he has now, and not anything that comes in after the father's death. And so that's why they made that distinction. But here, when they gave their answer that this is Baraita is talking about divorce, they were saying it. They were following the Yehuda Nasi's opinion. The Yehuda Nasi says a firstborn gets double, not only of what's muhzak and already in the father's property, but even that which comes in after the firstborn also gets that. So you see, he doesn't make a distinction between ra'ui and muhzak, and therefore, according to the B, this distinction between land and cash, either way, would not be relevant, because he doesn't matter. Even if it comes in after, we still consider it part of the inheritance, and therefore, in the case of the woman, even if it came in after she died, the husband should still get it. And that's why, according to the B, follow in the footsteps of the B, Rabbah and Rav Nachman have to say, we're talking about a case where the entire injury happened after she had already gotten divorced. So the husband has nothing to do with that, with the payment of that, except that for the Vladot. Yes, for the Vladot, he's the one that made her pregnant, and even if they were divorced at the time that he made her pregnant, that wouldn't matter. The father of the fetuses gets the money for the fetuses, even if they were never married. But this is the case that the Baraita is talking about, where the wife, her heirs get it because she was divorced, and in this case, everybody would agree, even Rabbi Akiva, who says that in general a husband inherits his wife. The exception would be kofed, because kofed is only owed, the whole payment only kicks in after she's already dead, and so there's no possibility that the husband can inherit that, because it only comes in after, and this case where only when they're already divorced. But if they weren't divorced, then Rabbi Akiva would say that the husband gets and she dies, the husband gets the payment, since the payment was already in effect, was already owed, and according to the B, there is no difference between whether it comes in later or not, and so the payment will go to the husband if they're married, and her heirs only keep it if they had been divorced. Next, we discuss an animal that kills unintentionally. Amar Rabbi Shimon ben Lakish, Shor she'emit et ha'ebed shelo bechavana, patur me-sheloshim shekalim, shnemar kesef sheloshim shekalim yiten ladonav, v'ashor yisakel. Kol zman she'ashor b'skila, ha'be'alim meshalemin sheloshim shekalim, and ha'ashor b'skila, and ha'be'alim meshalemin sheloshim shekalim. Resh Lakish teaches that if an ox kills a slave, but it does it unintentionally, the owner does not have to pay 30 shekel. How do you know? Because the pasuk says that in a case where a shor mo'ad kills a slave, the owner has to pay 30 shekel to the owner of the slave. The owner of the ox has to pay 30 shekel to the owner of the slave, and the ox gets sikila. So you see that these two laws are connected. Only when the ox gets sikila, then the owner of the ox has to pay 30 shekel. But that would only be if it has intention. You don't kill the ox for doing something unintentionally and meant to do something else and ended up killing a slave. You don't kill the ox. So if you would kill the ox because it did intentionally, then you have to pay. But if you do not kill the ox because it did it unintentionally, then the owner also does not pay the 30 shekel. So that's it. It's all or nothing. Both punishments or neither punishment. That's Resh Lakish's chidush regarding the payment of 30 shekel to a slave. Rabbah gives a parallel statement regarding kofir. Amar Rabbah, shor shemit ben horin shelo bechavana patur mi kofir, shene'emar, hashor yisakel v'gam be'alav yumat. Im kofir yushat alav, kol zman shashor biskila, be'alim meshalemim kofir, and hashor biskila, and be'alim meshalemim kofir. Rabbah teaches that an ox that that kills a free person, not a slave, free person, but he does it unintentionally. He does not have to pay kofir, because the pasuk says, and regarding shor mo'ad, that kills a person, that the shor gets sikila and the owner dies. So, but the owner doesn't have to die because he can pay ransom. So you have these two punishments: the animal gets sikila and the owner pays ransom. So these two are linked together. Only when the ox is killed with sikila, then the owner has to pay the kofir. But if a case like this, where the animal killed but without unintentionally, then since it doesn't get sikila, the owner also does not have to pay kofir. Okay, very good. Seems simple enough. But we're going to challenge it from Abaye. I was going to challenge it from my Mishnah in Masechet Ketubot. Itibe Abaye. Hemit shori et peloni, o shoro shel peloni, hareze mishalem al pi atzmo. My lav kofir la damim. The Mishnah teaches that if there's no witnesses, a person comes and admits and says, my ox killed that person, or my ox killed the ox of that person. We're focusing on this one, that I admit that my ox went and killed a person, but there are no witnesses. Since there are no witnesses, there's not going to be sikila to the animal, right? You don't, even based on admission, you don't give death penalty to the animal. And yet the Mishnah says that one pays, one pays. So what is he talking about? That's the words of the Mishnah. A person does pay based on his own admission. Well, what is he paying? Is he not paying kofir? Even though the animal does not die in this case, because it's only by admission, no witnesses, nevertheless he pays kofir. This goes against the statement of Rabbah. A good question. And so we answer, la damim, no, we're paying money, just monetary damages, not kofir. There are cases where kofir and damim would be different. For example, if you evaluate kofir based on the mehamazik, then that would be very different from the damim, which is based on the damage to the nizak. Here, the nizak is killed. Now, I mean, if an animal goes and gores and causes injury to another person, certainly I would have to pay. So if it kills the person, certainly killing includes injury. So just because the animal doesn't get killed and I don't pay kofir, doesn't mean I go scot-free. I at least have to pay for injury. That's what I was talking about. When there's no witnesses, and but I come and admit my animal killed someone. The animal doesn't get killed. So therefore I don't pay kofir. But when it says in the Mishnah I have to pay, we're talking about damim. It's a monetary payment. Good. I damim emasefa. Fine, that works as an answer to the resha of that Mishnah. But look at the continuation of the Mishnah. Hemit shori et avdo shel ploni eno mishalem al pi atzmo v'im damim amayla. Continuation is, if I come and admit that my ox killed someone else's slave. Again, there's no witnesses, so we don't put the animal to death for doing this. And here the Mishnah says, I do not pay based on my own admission. So if, okay, I certainly understand, I'm not going to pay the 30 shekel, because we just established Resh Lakish's rule that you only pay 30 shekel when the animal gets killed. But here, there's no witnesses, the animal doesn't get killed. I'm not going to pay the 30 shekel. Also, the 30 shekel is a fine, and now I wouldn't pay a fine based on admission. So that makes sense. It's not talking about this makes sense if it's talking about the 30 shekel payment, because 30 shekel payment will not be paid based on admission, and also won't be paid any case where the animal does not die. So the sefa makes sense if you're talking about a 30 shekel payment usually that you give for a slave. But if the resha is damim, and then the sefa should also be talking about damim, and if my ox if it caused injury to your slave, would I not be liable to pay money for that injury? So here too, I could say, if we're talking about injury in the resha, then this should also be talking about injury. And why not? Why don't I pay? I should have to pay injury in both the resha and the sefa. Okay, very powerful question. Amar le, Rabba answers Abaye's question. Yachena lashan yelach resha damim v'sefa kenas mihu shinuya dechika la meshanena lach. Rabba says, listen, I could have answered you with a flimsy answer that indeed the Resha is talking about a monetary payment and the Sefer is talking about a fine, the 30 shekel. But indeed, yeah, you would have to pay a monetary amount in the Sefer too. Just the Sefer is not be talking about that. But that is a forced answer that's easily rejected because it's not a very good answer to say that, the Resha is talking about a different type of payment than the Sefer, right? Because if it's talking about the same payment, then one would have to pay in both. And if it's talking about the standard payment of kofed or the 30 shekel, then one would have to pay in neither. So it's not a very good answer to say that the Mishnah is talking about two different types of payments. So I'm going to give you a better answer than that, right? See, so you better appreciate this better answer because I could have pushed you away with an easy answer, but here's the better one. Edi v'edi damim mihu. So both the Resha and Sefer are in fact talking about monetary payment for damages. Nevertheless, even in monetary payment, there is a different distinction between a free person and if the victim is a slave. And for a slave, one does not pay not even damages if there are no witnesses. How do we know that? As follows: Ben Chorin b'Shalom Kofed al pi atzmo. So in Ben Chorin, a free man ox kills a free person. There is a case where I would have to pay kofed even based on my own testimony. And therefore, it would make sense that I also have to pay damages based on my own testimony. Whereas, as we're going to see, for Eved, there is no case where I would have to pay knas based on my own testimony, and therefore, I also don't have to pay damages based on my own testimony. That's the structure of the argument. So let's fill it in. Where is a case where I would have to pay kofed based on my own testimony? See, the problem is, kofed, by the way, is not a fine. So theoretically, you could pay kofed based on testimony. But the thing is, as we saw above, that anytime there's no payment, anytime the ox doesn't get killed, then there's no payment for kofed. And so usually, when there's no witnesses, the ox is not going to get killed. So we have to figure out a way where somehow there are witnesses and the ox gets killed, and yet that's not sufficient for me to have to pay the kofed, but the kofed is only paid because of my admission. So how can we concoct such a scenario? You'll see here. In fact, there were two witnesses, and the witnesses say, we saw this, your ox, kill that person. However, the witnesses just don't know if it's a shor tam or a shor mu'ad. Now, either way, whether it's a tam or mu'ad, the ox is going to get killed. Any ox that kills a person, the ox gets sikila. So in this case, the ox would definitely get sikila. However, kofed payment is only given if it's mu'ad, not if it's tam. So therefore, I don't have to give kofed payment because the witnesses did not say whether it's tam or mu'ad. But then the owner says, although the witnesses did not say that it's mu'ad, I want to admit to that. So now we can combine the two witnesses who say for sure that there was something that was killed here by my person was killed by my ox, and I come and add that information that it was in fact mu'ad to mishalem kofed al pi atzmo. That's a case where I would pay kofed, because in this case the ox is definitely getting killed based on the witnesses. So now my admission just adds the necessary missing information that it's mu'ad, and I pay kofed based on my own testimony. Since there is such a scenario where I pay kofed based on my own testimony, therefore it makes sense that that also when there is no witnesses, I should have to pay something. It's not going to be kofed, but it's going to be a payment of the value of the damage, which is a monetary payment. So it makes sense, since there is a scenario, I'd have to pay based on my admission, a kofed, so too, I have to pay damages. But there is no such scenario regarding Eved. Eved does not pay knas based on his own admission, based on the admission of the owner, because what would be a parallel case? Witnesses came and said, they saw my ox kill a slave. but they don't know if it's tam or mu'ad. So in this case also, the animal is going to get sikila, surely. Okay, good. But I don't know if it's tam or mu'ad. If it's tam, I don't pay the 30 shekel. If it's mu'ad, I do pay the 30 shekel. Mu'ad hu lamishtalem kenas al pi atzmo. Even when the owner admits that it's a mu'ad, and so it seems I have all the necessary ingredients because the shor is killed no matter what. So we have no problem with the statement that we started off with Resh Lakish. Nevertheless, I still would not pay the 30 shekel because that is kanas, and that's just a fundamental rule. One does not pay a kanas based on one's own admission. And even over here, the admission is only adding one ingredient. I already know that the animal killed based on the two witnesses. Fine, that's sufficient to kill the animal. But it's not sufficient to pay kanas, and I can't pay kanas based on my admission that it's mu'ad. Since there is no such scenario where I would have to ever pay the kanas based on my own admission, so too, when there are not two witnesses, there aren't two witnesses at all, and I just come and admit my shor, which is mu'ad, killed a slave, I do not pay, certainly not kanas, and I do not even pay for the damim, and that's how Rabbah says I can explain that Mishnah in Ketubot, that the entire thing is talking about damim, and there is very subtle but clear difference between the two, right? The difference boils down to that the 30 shekel payment to a slave is a fine, but kofer is not a fine. Kofer is a payment, but it's just that it's linked to, both of them are linked to the killing of the shor, and so they cannot, the kofed or 30 shekel cannot kick in unless the shor is killed. So if there's no witnesses, the shor won't be killed. Nevertheless, when there's no witnesses, there is still damim to be paid regarding killing a free person, because kofed in its essence is not a fine, whereas killing a shor without witnesses, I do not pay damim because the 30 shekel payment is a fine in its essence, and so that translates into a difference of whether there is payment at all when there are no witnesses. All right, so all that seems like a very good. We worked very hard to get an answer, but we're still not going to be satisfied. Mativ Rav Shemuel bar Rav Yitzchak. Rav Shemuel bar Yitzchak asks a question from the following baraita. Kol shechaya beben horin, chaya be'aved, ben bechofer, ben bemita. This gives a general rule that any time an owner is liable to pay for his ox that kills a free person, he is liable also when it kills an aved. And that's true both for kofed and for putting the ox to death. Now, what does this mean? Kofed be'eved mi'ika? What do you mean, whether it's a free person or it's a slave? And you mentioned kofed. There is no such thing as kofed regarding eved. It's the wrong category. Ela lav damim. So rather, when it says kofed here, it must mean a monetary payment. What you see here is that this baraita equates ben hodin and eved. Regarding mita, we got when there's two witnesses, you put the ox to death. Otherwise, you don't put the ox to death, and that is true. That's the same for killing a free person or an aved. But we just established a minute ago, Rabbah's answer in that Mishnah says it's all talking about damim, and here we just proved that this baraita is also talking about payment of damim, and yet here it says that the owner is liable in any case where a free person or a slave, the same. So that would mean that when there are no witnesses, has to be the same, right? But you just said that for Ben Chorin, I have to pay damim when there's no witnesses, but for Eved, I don't pay damim when there's no witnesses. But here it says they should be the same. All right, serious challenge. Ika da amre hu motiv la v'hu mefarek la, v'ika da amre amar le Rabbah. So the following answer, some say it was Rav Shemuel bar Rav Yitzchak who gave the answer. He gave the question and he gave the answer too. But others say that it was Rabbah who gave the answer. Hachi katanes is the Braita. This is how you have to explain it. You have to add a few more explanatory words. Kol shechayab beben horin bechavana al pi adim. kofir, chaya be'eved, kenas. Anytime the owner has to pay when his ox kills a free person, and when would he have to pay? When the animal kills a person intentionally, and there are witnesses there, in which case you kill the animal, and then the owner has to pay kofir. So in the same scenario where there are witnesses and it kills on purpose, if it's an eved, he doesn't pay kofir, but he has to pay kanas. The animal gets killed and they pay kanas. So that's where they're equal. And there is another case when they are equal and both pay damim, right? In the first case, they pay kofir or the kanas of 30 shekel. But there's another case where both scenarios they would pay damim, but neither of these cases have to do with admission. So let's explain first. Damim. So when my ox kills a free person, but it does it without intention, although there are witnesses there. So since there are witnesses, since it did it without intention, the animal is not going to get the death penalty. Since it doesn't get sikila, the owner also does not have to pay kofir. Even though he doesn't have to pay kofir, he still has to pay for damages, and that is the same regarding an eved. If my animal kills a slave, but it did it without intention, so therefore it does not get sikila, so I will not have to pay a fine. But there are witnesses that it killed, so even though it did it without intention, nevertheless I have to pay damages. I don't have to pay the kanas because kanas is linked to death penalty, and the ox doesn't get that death penalty because it did it without intention. Nevertheless, you still have to pay damim. So here there is a case regarding an ox killing a slave where one has to pay damim. That's true, but it's not a case of admission, because if it were admission, if it's admission, then since there is no possibility of ever paying a fine with admission, so too there's no damim with admission. But if there are two witnesses, in which case you would have to, normally if it was b'kavanah, you would get death penalty and you'd pay the kofir. So since there is such a scenario, therefore if you're just missing the death penalty because it's shelo b'kavanah, then you do pay damim for eved. So Rabbah answers, this is what this baraita meant. This was very terse, and you have to add a lot more words, but in essence, that's what this was talking about. But this was not talking about a case of admission. So he sticks to his principle that he said before, that when it comes to an owner admitting, and this is what the Mishnah in Ketubot said, one only has to pay in the case of killing a free person, damim, but one does not have to pay upon one's ox killing a slave. One does not pay anything, certainly not the fine, and not even damim. And so that's how we resolve all the questions against Rabbah. Rava next asks a follow-up question based on what Rabbah just ruled. Amar le Rava, ihachi isho shelo bechavana al pi edim neshalem damim. Rava tells Rabbah, if you are correct that even when someone does not have to pay ransom because, let's say, my ox killed someone else, but it did it without intention, and therefore, since the animal does not get killed, so I do not pay kofir. Nevertheless, even when, for my ox that kills, I don't pay kofir, I still do have to pay damim. I have to pay damages assessed by the value of the victim, right? If you just introduced this law that you have to pay damim even when you don't pay kofir, I have a question. What does that connect transfer from shor to esh? Isho. If my fire goes ahead and kills someone without intention, I didn't intend to kill them, it was by mistake, my fire got out of control and killed someone, and there are witnesses. Now, I'm not going to get the death penalty because I did it without intention, but maybe I should have to nevertheless pay for injury, right? So based on your ruling, should we not transfer that also to fire? Now, we ask about a clarification about Rava. Why is Rava assuming that I wouldn't pay? He's asking, like, how come you don't transfer this law of payment of damim also to Esh? Well, and you don't pay if you pay damim for shor. Why don't you pay damim for fire? So now we're asking, well, how does Rava know that you don't pay for fire? Maybe you do. Okay. So now we're gonna look. We're gonna try to find 3 ways in which Rava knows that you don't pay damim for fire. In the end, we're not going to find a source, and we're going to end up saying, actually, Rava wasn't sure about this very question, whether you pay damim for fire that kills unintentionally. And that's what his whole point was, should we transfer this or not? Right? He's actually asking a question, not a challenge. But right now, we're reading this Amar le Rava as a challenge. And so Rava is challenging it because he assumes, right now, this is what we think, that one does not pay damim for fire. So how do we know that you don't pay damim for fire? Here's a possible source. Number 1, ilema miditnan, maybe it's from a Mishnah later in this Masechet. Hayagedi kafut lo ve'ebed samuch lo v'nisraf imo chayav. Eved kafut lo ugdi samuch lo v'nisraf imo patur. If there's a goat that's bound up next to bound to something, next to a pile of hay, and there's also a slave there. The slave is not bound up, and I go and I burn the hay, and it ends up killing the goat, because the goat is bound up and can't get away. And now it kills the slave too, but the slave was not bound up, and the slave should have run away. So I'm not liable for killing the slave, so that's not my problem. I do have to pay for the hay and the goat, because this is monetary damages that I caused. And I have to pay for it. I am not chayav mitah for the eved. However, if the slave was also bound up to a pole there, and the goat also was bound up next to it, and I burnt everything all together, now I caused the death of the slave directly. So I am liable to the death penalty. Because I'm liable to the death penalty, patur, I do not have to pay. So you see here, what does it mean pay? I don't have to pay anything, not even damages. So maybe Rava learned it from here, because here's a case where I killed the slave, but it was by mistake. And we're assuming right now is by mistake, and yet I don't have to pay anything at all. So is this not a source to teach me that I don't have to pay? Shakish says no. This is talking about a case where I went purposely and directly lit the slave on fire, and then to spread to the other things as well. So here I am liable to death penalty, and therefore we do apply kim le b'draba mineh. And that's why I don't have to pay anything at all. Certainly, when I'm liable to the death penalty, there I don't pay anything, not damim, not nothing. And that's what this Mishnah meant. It was simply showing a contrast between a case where the slave could have gotten away, in which case it's the slave's own fault that he decided to stay in the fire and get killed. That's not my problem. So then I have to pay for the all the damages. But if the slave is there and he can't get away, then I'm liable to a death penalty. So this is not a source for Rava's assumption that there's no damim regarding Esh when I kill unintentionally, because that was actually intentional, and I get the death penalty in that case. So maybe Rava knows it from here. Chomer ba'esh mi bebor, sha'esh mu'edet lechol ben davar hara'ui la, ben davar she'eno ra'ui la, ma she'en ken bebor, ve'ilu sha'esh meshalemet shelo b'chavanat damim, ma she'en ken bebor la katane. There's a braita that says, in what way is fire more stringent than a pit that causes damage? Because a fire is considered forewarned to consume, whether it's something that it normally does consume, meaning fuel, or something that's not fuel. If I light something on fire, it doesn't matter if it's wood, that's usually fuel, or some other item that I wouldn't usually burn, I'm still liable for burning an item no matter what it is. That's not true for bod. But I'm only liable for certain things. An animal that falls in, I'm liable. Vessels that fall in, I'm not liable. So that's a stringency of fire over bod. That's the end of the Braita. Look how we notice that it does not say that a fire I have to pay when I light a fire without intention and it kills someone, that I have to pay damages, and not so for bod, but I don't pay damages. You see, it doesn't say that here. Since it doesn't say it, it must be because it's not true. That a fire also, I don't have to pay damages, even when it kills someone unintentionally. So is that Rava's source for his assumption that damages are not paid for esh? We say not necessarily. This is an argument from silence. Dilma tena v'shi'er. Maybe this Braita mentioned one item, and maybe there are more differences. And maybe this esh is in fact another difference where I do have to pay damim for esh. It just didn't bother to mention it. So therefore, that's not a source either. So we tried two sources, but in fact we end. You're right. Ravad did not know that, and Ravad was actually asking this very question: Isha shelo bechavana mi meshalem damim o la? When a fire kills someone, but it was unintentional, I'm not getting a death penalty. Do I have to pay for the damages or not? Mi amrinan, here's the two sides of it. Gaveh shor hu de bechavana meshalem kofer, shelo bechavana meshalem damim, aval isha de bechavana lo meshalem kofer, shelo bechavana name lo meshalem damim. And here's two ways to compare shor and esh. Regarding shor, where if my shor kills someone intentionally, then I have to pay kofer. Shor Mo'ad, where there are witnesses, then I have to pay kofer. But if it does it without intention, then I don't pay kofer, but I do pay damim. So it seems damim and kofer go together. They're a pair. Kofer when it does have kavanah, damim when it doesn't have kavanah. That's all for sure. But for fire, where if I light a fire with intention to kill someone, I don't pay kofer. There's no such thing as kofer in that case, because I get the death penalty. Right? It's not like shor where it's indirect fire. I'm doing it. So I would get the death penalty. There's no such thing as kofer. So too, if my fire kills without my intention, unintentionally, then there's no damim. Maybe there's only damim when there is kavanah. Sorry, when there is kofer, but if there's no kofer, there's no damim. That's one side of it, to say that there is no damim payment for esh, or dilma kevan de gabe shoro shelo bechavana afagav deleka kofer meshalem damim gabe shoname afagav de bechavana lo meshalem kofer shelo bechavana mihat meshalem damim. Or maybe there's no difference and there's no connection between kofer and damim, and we'll say, since regarding the ox that kills without intention, even though there's no kofer, you still have to pay damim, right? So it has nothing to do. There's no kofer, but you still pay damim. So too regarding fire, where there's never kofer, even if I burned someone on purpose, so too, just because there's no kofer, it makes no difference. Shelo bechavana, when it's done without intention, when there's no kofer anyway, not even in any case, I would have to pay damim, right? In other words, anytime there's no kofer for a short, I do pay damim, but that's when there's no kofer, I pay damim. So when there's never kofer, I also would have to pay damim. Velayad inan teku, and we don't know the solution to this, but this was Rava's question. He wasn't challenging Rabbah. He was just wondering, maybe we could try to solve this dilemma from Rabbah's statement. Next, after discussing at length the opinions of Rabbah and Resh Lakish, we're going to see an opposing opinion. Ki atad Rav Dimi Amar Rabbi Yochanan, also from Medinat Yisrael. Rabbi Yochanan says, a colleague of Resh Lakish, Rabbah is from Bavel. So Rabbi Yochanan teaches, Kofer matamud lomar im kofer, lerabot kofer shelo bechavana ke kofer bekavana. In the case when an ox scores a free person on purpose, shor mo'ad, it says that really that the ox not only gets the death penalty, even the owner should get the death penalty, but If im kofer yushat alav, if he wants, he can pay ransom. Now you don't need the word im there. It could just say kofer yushat alav. Don't kill him. He can pay ransom. Why does it have to say if? That's an additional. That word is an inclusive word to include that there is kofer payment, even when the animal does not kill intentionally, just like one pays when it does kill intentionally. So this is a Yochanan, the opposite of Rabbah's statement that we learned above. Rabbah said that the kofed payment is only when the ox kills on purpose, because that's when you kill the ox, and if you kill the ox, then also you pay kofed. But if it's not intentional and you don't kill the ox, then you don't pay kofed. Rabbi Yochanan says, no, I disagree. Rabbi Yochanan is before Rabbah, so he doesn't have to disagree with him. Rabbi Yochanan does not agree with that position. He says im includes kofed in both cases. Amar le Abaye, ela me'ata aved name, ma'ata modomar im aved, lerabot aved shelo bechavana ke'aved bechavana. Abaye says, if Rabbi Yochanan disagrees with Rabbah because of the word im, notice that regarding Eved, it also says the word im. The pasuk says, im Eved yigach hashor or ama. If the ox kills a slave, it's part of the scenario. It sets up the scenario. It says if it should be a slave that it kills. So it also has the word im. So maybe that word im also is including that for an ox kills an eved, one has to pay the 30 shekel of silver, not only where it does it on purpose, where the ox gets killed, but even if it does it by not intentionally, where the ox doesn't get killed, still the owner has to pay 30 shekalim, and that would go against Resh Lakish. So maybe you'll say, oh yes, that's indeed so. Rabbi Yochanan would say that Rabbi Yochanan would say, in all cases, just like when it kills a free man, you have to pay kofed. So too, when my ox kills a slave, whether bekavana or shelo bekavana, I have to pay 30. Maybe indeed Rabbi Yochanan would say that. Why? How could he say that? Resh Lakish said not so. That if an ox kills a slave without intention, one does not pay the 30 shekalim. Amarle, Gabra Karamet, Rabbi Dimi said to Abaye, what, you're asking one person against another? They are contemporaries. Rabbi Yochanan and Lakish were chevrutot. They can argue with each other. It's not a Tana. And so what? Yes, in fact, Rabbi Yochanan is in fact could be arguing against Resh Lakish. And sure enough, Ki ata Rabin amar Rabbi Yochanan, when Rabin came from Eretz Yisrael to Bavel, he said this explicitly in the name of Rabbi Yochanan, Ayved, matomod omar im Ayved, lerabot Ayved shelo bechavana ki Ayved bechavana. The pasuk could have just said Eved. The extra word im comes to include that one pays 30 shekel if his ox gores a slave, whether it did it intentionally or not intentionally. Good. Resh Lakish name nema med'ayved im ayved ladarish kofer im kofer name ladarish. Now, since Resh Lakish does not agree with this derivation of the extra word im regarding Ayved, he doesn't agree with that derivation, so it would seem that Resh Lakish should also not agree with the derivation of Kofer im Kofer, and so therefore Resh Lakish must agree with Rabbah that regarding the animal killing a slave, killing a free person, also one does not pay when it's not bekavana, and so because he doesn't agree with Rabbi Yochanan in this derivation, he doesn't agree with Rabbi Yochanan in the second derivation at all, right? Is that true? We say not necessarily. Amreh la eved im eved la darish, kofer im kofer darish. It could be that Resh Lakish would not follow the derivation of the extra word im regarding Ayved, but he would follow it regarding kofer. Umayshana. What's the difference? Isn't it the same syntax? The answer is no, it's not the same. Eved im Ayved la ketiv im kom tashlomin. Kofer im kofer ketiv im kom tashlomin. The word Eved im Ayved, the word im Ayved appears in the presentation of the scenario. If the ox would kill a slave, then it says you pay 30 shekel. So there, it's just setting up the scenario if this happens. So there's no reason to think that the word im is extra. You just need the word im to set up the scenario, but the 30 shekel remains as is, and that's where the Resh Lakish says the 30 shekel is connected to the killing of the ox. Only if the ox gets stoned, then you pay 30 shekel, otherwise not. Resh Lakish holds that to be true. But regarding kofed, im kofed, there the word im is said not in the setup of the scenario, but in the verdict that the owner deserves a death penalty, but he can pay. So the word im is said regarding the payment, and therefore it is an extra word there, and it comes to add that one does pay kofed, whether the animal killed intentionally or unintentionally. And therefore, it could be that Resh Lakish splits the difference, and he thinks that one only pays 30 shekel to a slave when the slave kills intentionally, but one has to pay kofed no matter what, whether the ox kills intentionally or not. Baruch Adonai Ta'olam, Amen v'Amen.